Welcome to the second webinar in the series of Elder Law Trainings for 2024. We're glad you could join us. A couple tech tips before we get started. Please make sure you're on mute. And we will put the link in the chat in just a moment to the materials for this session and all the sessions. We have one folder and we'll have subfolders for each session. So in the link I'll put up, you can find the recording and the PowerPoint from the first session, as well as the PowerPoint for today. And then the recording for today will later be put in that same folder. If you are requesting CLE credit for this webinar, you will need to do the Zoom polling questions that come up during the webinar, and also do the survey that pops up at the end. We can also send you the link to the survey if you miss it when it pops up at the end of the day. All right, so with that, we will get started with part 2 of the series, which will cover institutional Medicaid. And today, Miriam's going to focus on resources and transfer of resources with a little review. And so with that, I will pass it over to Miriam Sheline from Pro Seniors.
Thanks, Melissa. Good morning, everyone. Great Friday morning to spend some time learning institutional Medicaid, just what we all want to do on a Friday morning. So what we did last time, obviously, again, welcome to part 2 of our trainings, 2 of 9, okay? And today we're going to pick up sort of where we left off on the institutional Medicaid trainings. And so I'm going to sort of do a repeat of a little bit of what we talked about last or 2 weeks ago, just to give you a feed into where we left off. Okay, so one of the things we talked about with regard to Medicaid is that there's lots of calculations we do. We're talking about nursing home Medicaid, or it could be waiver Medicaid as well. And the numbers, as we talked about, change frequently. So on our website at proseniors.org, if you click on the resources and then click on the Medicare Medicaid eligibility dropdown, it will take you to this page. And as you scroll down, number 1, you will see that we have a link for all the rules for the Ohio Department of Medicaid. If you click on that, that will take you to this page that has the links for the various regulations. Also on that same page that we were on, if you scroll down a little further, you'll see a box that says Institutional Medicaid. And last time I sort of highlighted the monthly income allowance numbers and the excess shelter allowance numbers, etc. But if you also scroll down that same page a little further, you will see our community spouse resource allowance numbers. And there's many other numbers that are on that page for Medicare premiums, et cetera. But this is going to be more where we're talking about today. Okay. So just to review, what are we talking about? The question is how we qualify for nursing home Medicaid or waiver Medicaid, institutional Medicaid. And there are 2 prongs. On the financial thresholds, you must be income eligible and you must be resource eligible. So just as we did last time, I will break as we go through just to see if you have any questions. Feel free to put those in chat, and then Melissa will be able to highlight those for me. We can stop and discuss if there's any questions. So as you go along, if you want to put those questions in chat, that's fine. And as I said, we will break frequently to cover any possible questions on each sort of subtopic. Okay. So income eligibility is what we covered significantly or substantially last time. So briefly, just as a refresher, the applicant's countable income must be below 300% of SSI to qualify for institutional Medicaid. This is a gross income number, but remember, we do say countable. That term countable will come up frequently and will come up in our resource analysis as well. But generally speaking, there's not a lot of exclusions for the institutionalized spouse's income. So generally speaking, it's going to be gross income. You cannot deduct medical expenses, Medicare premiums, et cetera, for Medicaid income eligibility. Okay, so in this calculation, you are not looking at community spouse's income, just the institutionalized spouse's income and their gross income. So that's before deduction for taxes or garnishments or deductions for anything, okay? And if the income is above 300% of SSI, which is $2,829 in 2024, the Medicaid applicant is not going to qualify. So what do? We have to reduce their income by setting up a qualified income trust or QIT. It is only appropriate for individuals receiving long-term care services, which includes our waiver services. And what you have to do is you have to put the excess income, i.e. the income above the $2,829 into the QIT each month so that it becomes essentially the trust's income and not the Medicaid applicant's income. Then the Medicaid applicant will qualify for Medicaid for income purposes. But again, that is our income eligibility piece. Now we move to what do they owe to the nursing home or to the passport provider. This is post eligibility. So when we go to that stage, we take off the income eligibility hat, we put on the patient liability hat. And as we, I should really, sorry, went too fast. But any case, with regard to the qualified income trust, simply because you put it in there, it still counts as your income for post eligibility. And you cannot get retroactive coverage because you are not eligible until you fund the QIT in that month. So how did we calculate patient liability? This was our formula. You take the individual's gross income, you take out any excluded income, you take off their personal needs allowance, which for nursing home is $50, for passport is $1,839, and for the assisted living waiver is $943. But with regard to assisted living waiver, remember you still have to pay room and board. So that is another deduction of room, a separate deduction of room and board, which is $943 minus $50 or $893. Then we had to calculate the monthly, take off the monthly income allowance for the community spouse. If there's dependent family members, there's a deduction for the family allowance. Now you can deduct health insurance premiums, copays, and deductibles. And you can deduct unpaid medical expenses to come up. And if you have a QIT, you can deduct any bank fees that you incur up to $15 a month to come up with what the resident is going to owe in the way of patient liability. So in that formula we did, you have to figure out what's the income allowance. This is the allowance of the income, the amount that the community spouse can keep from the institutionalized spouse's income. And this was, you started with the standard number of $2,465. You add to that the excess shelter allowance, and you compare that to the cap or the top level of the standard triple MNA. And then you take off the community spouse's income to come up with the monthly income allowance for the community spouse. And in order to calculate that, you needed to figure out how to do the excess shelter allowance. The excess shelter allowance is essentially taking the community spouse's expenses for living expenses in the way of mortgage, property taxes, homeowner insurance, HOA fees. Assuming that they are paying utilities, you would add the standard utility allowance of $724. and subtract from that the standard shelter allowance of $739.50, and that equals your excess shelter allowance that we are adding to the monthly income allowance calculation to figure out how much of the income the community spouse can keep. All right. From there, we went on to talk about resource eligibility. In this, we have our spreadsheet that basically we have to do a resource assessment, followed by the allocation between the husband and wife, or between the spouses. And again, because we're coming up now with a resource allowance for the community spouse, then spend down the resources to $2,000 to become resource eligible. And there's our spreadsheet that we talked about before. Basically, we had to first start with determining the snapshot date. What is a snapshot date? That is the date we are going to value the resources for the allocation. That date is the first day of the first month in which the institutionalized spouse is continuously institutionalized. So that could be, 6 months prior, but it is not the date of application. It is the date that they went into the nursing home, essentially, or the date they apply for passport services. So figured that date. Now we are going to list all of their resources. We are going to determine which resources are excluded and scratch those off the list. Then we will look at whether or not there are resources we cannot access, because of course, accountable resource is one that we can be converted to cash. The key here is our resident suffering from a physical or mental impairment such that they cannot get the verifications or they cannot access that resource. If so, then those resources should be excluded. And that gets down to, okay, what's left? These are our accountable resources, at which point we are now going to allocate those between husband and wife or between the spouses. So before we move on, any questions as to the review that you all might have thought of in the last 2 weeks, or anything that you wanted to follow up as to clarification on the income pieces or the excluded resources?
Hi, Miriam. This is Mary Kickle. Could you give an example of a non-accessible resource?
Sure. So this would normally be the situations we had were basically the resident did not have power of attorney, did not have anybody capable of managing their finances. Okay. And the Jobs and Family Services, basically she had a life insurance policy, which grew in excess of the $2,000 limit for the cash value, but nobody could cash it. Nobody could transfer it to a funeral home. In that case, the rule applies to say, county caseworker, you should exclude that resource. You can turn it over to the county, to county prosecutor to make that resource available. But until it is made available, you should not count it. So it basically will apply to any resource that would normally be countable, but because of a physical or mental impairment, they cannot liquidate it, or in some cases, even get a verification. Okay, so this is basically JFS saying, go get a guardian. The answer under the ADA is you can't require the Medicaid applicant to go get their own guardian. Okay. The other example of that would be sort of a shared interest you have a joint owner on this property and you can't sell it, and you document that you've made demands to sell it, and the joint owner, which is not the spouse, won't sell it. Okay, so that would be the other example. So, any other questions?
Yes, there's a question for Mark. Is there a computer program available to practitioners to determine eligibility?
No. Sorry. No, there is not, because there's just frequently too many varying factors in this. The only way to do this, and I'm sure that the county JFS may has a program that they plug all the different information into. They don't do these on paper anymore, but in the sense of a computer program out there for the general population, no, there is not.
That looks like it for questions for now.
Cool, great. So after 2 weeks, you just know it all on income. Great. Oh, just kidding. So we move on to the next piece, which is the resource assessment and the allocation between husband and wife. So here was just, sorry, there's our reminder as to excluded resources like the car, household goods, burial spaces, prepaid burial contracts, the home, and property listed for sale as fair market value, and long-term care insurance payments on the proper kind of long-term care policy. These are all excluded resources that we take off the list. So what is the point of the resource allocation? Just like the monthly income allowance, we are providing a certain amount of resources from the joint resources so that the community spouse is not impoverished. Okay. And this is a portion of the countable resources after we've taken off things like the home. And remember, when on this piece, we are looking at both the resources of this IS and the CS, regardless of how it's titled. So how does the community spouse resource allowance work? We have a floor and we have a ceiling and a 50-50 division between the two. Again, these numbers change every year. So the minimum is $30,828. The maximum is $154,140. And if so, and there's a 50-50 division between those, and they're recalculated each year based on the consumer price index. So let's look at step by step how this would work. Let's say, for instance, the joint countable resources are $32,828. Then what you're going to do is you're looking at that saying, well, community spouse gets $30,828. That's the minimum. And then the institutionalized spouse's share is $2,000. And now the IS is eligible. So it's not a 50-50 division at this point because the community spouse has to get the guaranteed minimum. In the situation, let's say their countable resources are $37,000. Again, the minimum is going to be for the community spouse of $30,828. And on the institutionalized spouse's side is $6,172. And the IS's share must be spent down to $2,000 before the IS qualifies. If their resources, for instance, are $67,828, now we are at a 50-50 split. And the community spouse's share is $30,828. And then the other $30,828 is put on the IS's side. And that $30,828 must be spent down to $2,000 for the IS to qualify. What if their resources are $100,000? Now it is fit again. The 50 split is going to be more than the minimum. So the community spouse gets the higher of the two. And now we're doing a 50-50 split. And the CS would get 50,000 and the IS would have 50,000, which would have to be spent down to $2,000 to qualify for Medicaid. If the resources are $309,040, we are still at a 50-50 split, but this is now the maximum allocation for the community spouse. This is the ceiling, 154,520. And then the IS has got a 1,005, 1,000. I sure want that 1,000 in there. Sorry, 154,520 must be spent down to $2,000 before the IS would qualify. What if they have 454,520? Well, now we no longer do a 50-50 split. Again, the community spouse has got the maximum allocation, which is 154,520. And so then the ISSI is now going to be 300,000, which must be spent down to $2,000. Okay. And again, the date we are valuing these numbers is the date the IS has been continuously institutionalized for a period of 30 days. And as we sort of talked about last time, if you have some of these higher numbers, the concern is that the community spouse may be privately paying for a considerable period of time. Then how do we calculate it to make sure she still gets her CSRA at the time of application, which may be a year or two later? And the answer is to look at doing this right, as soon as possible to lock those numbers in. What if you are paying for about a year or whatever, and there's interest accruals or increase in values? The answer is all of that is going to be on the IS's side. So the CS's number is locked in, and the rest of it has to be spent down to $2,000. So if you have interest accruals, et cetera, that increases the IS's part, that still has to be spent down. So basically, to qualify, it is going to be the CSRA plus $2,000, and that CSRA is calculated as of the first date of institutionalization. So let's look at some case facts here. For those who recall our couple, Julie and Jim, Julie suffers from dementia and permanently entered a nursing home on March 1st. She owns her home worth $100,000 free and clear. She has $6,000 in a checking account. She owns a 2006 Ford Focus. Her husband, Jim, continues to live in the home, although the deed is in Julie's name. She is able to direct. She doesn't want to return home. And they also have IRAs totaling $30,000, but they are not taking regular distributions. So to review with regard to the IRAs, if you're taking regular distributions under the rules, then the IRA itself is excluded because the distributions are counted as income and they become an excluded resource. If you are not taking regular distributions, then they are a countable resource. So let's look at our first poll question. I'm going to go back. I don't know if you can see my facts there, but we'll try it. There you go. So what amount of resources can Jim keep? What is his CSRA? Is it 134,000? Is it 18,000? Is it 36,000? Or is it 30,828?
Right, we have a little over half. We'll wait and give everyone another minute to think about this, respond. Also just note that we need a response, but it doesn't have to be the correct response for you to get CLE credit.
Does that include me?
That includes you.
Oh,
Hopefully you know the right response somewhere.
I think so. Yes, there you go.
All right, we will give everyone a few more seconds. Get your answer in, and then we'll close the poll. Okay, can you see those results, Miriam?
Yes, I can. Yes, I
All
can.
right.
Okay. So we've got a fairly big mix across the top. All right. So let's review that. Okay. The correct answer is 30,828. So how did I come up with that number? Recall the first thing we have to do in our example is take off the excluded resources before you calculate the CSRA. The CSRA is for accountable resources after we deduct the exclusions. So therefore, the home in which Jim lives is an excluded resource. The car is also an excluded resource. That leaves $36,000 in countable resources. But looking at the 36,000, remember, we have a minimum of 30,828 and a maximum of 154,140. So since their countable resources were $36,000, the Jim is going to be entitled to the minimum of 30,828. That means the countable resources that need to be spent down is the remainder after we deduct the 30,828. So let's look at these facts again and just do a little more. Okay. Let's start right here. We have a car worth $100,000. We have the $6,000 in a checking account. We have a Ford Focus. We have the home that Jim is living in. It's titled in Julie's name. That doesn't matter between the two of them. She's able to direct and she does not want to return home. That doesn't matter because Jim is living in it. Therefore, the home continues to be exempt. Now they have IRAs totaling $30,000 and are taking regular distributions. This means that the IRAs are excluded because the income is counted, or the distributions is counted as income. Instead of a Ford Focus, she owns a 2023 Mercedes. Does not matter. The car is exempt for any purpose when there's a spouse. Let's say Julie owns $100,000 in P&G stock. All right, so what do we do with that? Again, is our example excluded summary, the car, the home, and our burial spaces, prepaid burial contracts, etc. But in our example, the car and the home are excluded. So I have no idea. Somehow I have a red mark on here. Hopefully that's not on everybody's screen.
Yeah, we can see it. I'm not sure how to tell you to.
I don't know where that
get
came
rid of
from.
it.
I don't see that just that appeared. I have no idea. That appeared when we put the poll up. So sorry, guys. There we go. So here's our case facts again. All right, going through that. The home, Jim is living in it, so the home is excluded. The car is excluded. Okay. The IRAs taking regular distributions is excluded. So what do we have left? We have the P&G stock of 100,000 and 6,000 in the checking account. So our total countable resources are $106,000. We are going to have to divide that between them so that Jim's CSRA is going to be $53,000, and Julie's is going to have to spend down $53,000 to $2,000 before she qualifies for Medicaid. And there's our chart again. Again, they are in this range now for 50,000. What if we change our facts again a little bit? That Julie has an IRA totaling 20,000, is not taking regular distributions, but Jim is working and it has 100,000 in P&G stock in his 401k, which he cannot access until he quits. Well, this changes our facts to say, at this point, the home is still exempt. The Mercedes is exempt. The IRAs are now counted, but Jim's P&G stock, which he cannot access, is another good example of those resources that you cannot convert to cash. And therefore it should be also excluded. So the total resources in this example is going to be $26,000, which means Julie is eligible as of March 1st when she went into the facility. All of that 26 is going to be put on Jim's side as it's below our minimum CSRA. All right. Any questions before I move on to some of the other cool rules with regard to that?
Yes, looks like Mike has a question. Does the answer with Jim's 401k change if Jim is over 59?
If he can withdraw the money, okay, generally with regard to IRAs, et cetera, you can take distributions. But if there's limits on the 401k that says that you cannot, regardless of your age, because it's while you are still working, then the answer would be no. It really comes down to whether or not you can access it. So generally speaking, if you're over 59 and a half, you can make withdrawals, but your 401k may say you cannot until you are have left the company. So it would depend on those limitations. Other questions?
Yes, couple more. Mark asks, why is the stock considered as not convertible to cash?
Because they cannot require you to quit your job. So it's the same question. If you cannot convert it to cash because you can't withdraw it, they can't say you, Jim, must quit your job in order to access it.
And then he had a follow-up.
Sure.
Stocks are pretty easily sold.
They are sold, but if they're in the 401k, you can sell it and put it into something else, but it's still within the 401k. It's a matter of, can you take it out in order to pay your bills?
And then we have another question from Vanessa. What if there are penalties for taking withdrawals from a retirement account before age 59 and a half?
If there are penalties, we're going to talk about that under the spend down. So the cost of liquidating is always a proper deduction. It basically reduces the value. So if you take out 50,000 and you have to pay 2,000 in taxes or penalties, et cetera, that reduces. You didn't actually take 50, you took less. So it reduces the overall value, and it is a proper deduction. It's a proper part of the spend down.
Okay, I think that's it for questions for now.
Okay, great. So
Miriam, I'm sorry, I have
Yes.
one more question.
Sure.
So, like a Roth IRA where you could take a distribution at any time without a penalization, that would be considered accessible, correct?
that is correct if you can take the distribution. Okay, again, you get the same problem with your Roth in your 401k. It really depends on the rules of that 401k. Okay. So, couple of different extra rules. Once you do you have to transfer the IS's share at the time of the allocation? The answer is no, because they look at whoever's name is on the title as joint. Okay, regardless of who actually owns it. But you have a period of 12 months of protected eligibility. So after you are determined eligible, in our Julie and Jim's example, Julie's resources need to be transferred to Jim within 12 months after she becomes eligible. If she has not, they become accountable resource of Julie, because essentially the rules consider them to have been separated by institutionalization. What about the situation where the spouse is nowhere to be found? They've been married and separated for 20 years. The last time she heard, Jim was living in Arizona somewhere. Does that forever prevent her from qualifying for Medicaid? And the answer is no. Will they still look for Jim's resources? Yes. But she can establish basically the reluctant spouse. If the community spouse will not cooperate to make those resources available, and after the assessment, then she must be given notice. Wow. I have no idea what this is doing. Now we get other red lines. Sorry, guys, I have no idea where those are coming from.
The other ones went away. It's just the one from the beginning. So
yeah, this is very bizarre. Okay. So the community spouse must be given notice of the duty to cooperate in making the resource available. And the institutionalized spouse must assign support rights to the state. So you got to send them a letter basically saying, hey, you must give me these verifications. You must cooperate in paying your institutionalized spouse's share of debts, which community spouse ignores. And if they refuse to cooperate, then Medicaid must be approved. And then the case is referred to the state attorney general's office to see if they want to try to recover the funds from the community spouse for any payments made up to the IS's allocated share of the assets. So just sort of like what we talk about the physical or mental impairment, if the Medicaid applicant has done everything they can to get access to these assets and they provided their information, you cannot prevent them from getting Medicaid because a third party, in this case, community spouse, is not cooperative. And it just doesn't have to be the long distance or the missing spouse. It could just be the community spouse doesn't want to cooperate. That's fine. You cannot penalize the IS for that. And JFS can't say, go get a divorce as a condition of qualifying for Medicaid. Now, sometimes with a divorce, however, you can get a court order which gives everything to the community spouse. That's binding on JFS. Whatever the court order says, that supersedes what the Medicaid rules provide. JFS did try to tamper with this rule at one time and change their mind, because obviously I don't think they have authority to override what the court decides. So in that case, the CSRA is going to be the amount of the resources allocated to her in the court order. All right, so that's our allocation. The next step is going to be to spend down. So how do we spend down our resources? Being resource eligible on the last day of the month means you're eligible for the entire month. And I would add, as for retroactive coverage, we'll probably get that a little later too, but for retroactive coverage, you must be eligible for each of those prior months on the last day of that month to qualify for the retroactive coverage for that month. So what can you spend down on that's proper? You can buy things for either spouse. You could pay the legal obligations for either spouse. You could put the money into an excluded resource, or you can also talk to the Medicaid planning attorney about other options that might be a little more exotic. But for the most part, with most of our clients, these three are going to qualify, probably sample or handle what needs to be done. So let's look at our resources again. We have a house, we have a car, we have household goods, we have an IRA, and for this analysis, we're talking about not taking distributions. We have savings, we have an inheritance, and we have a life insurance with a cash value of $10,000. So our first thing, we've listed all these things. And step one is to scratch off the excluded resources to come up with the countable resources. And the answer I've got is $160,000. So again, our resource exclusions, the car, the household goods, the burial spaces, life insurance, the home, any property listed for sale at fair market value, long-term care insurance policies. In our sample, our countable assets were $160,000 because the house and the car were excluded. The IRA was counted because they were not taking distributions. At $160,000 of countable assets, we're in the middle of that CSRA, i.e. a 50-50 split. So we take off the top $80,000. Leaves resources allocated to the institutionalized spouse of $80,000. So now we can prepay the burial spaces and prepaid burial contracts for both husband and wife. We had cashed in the IRA, so there's a cost to that. We pay off credit cards. We do some home repairs. We pay off the car. We buy some furniture and clothes for the institutionalized spouse. We pay off the mortgage. We buy a Mediterranean cruise for the community spouse. Is that okay? Absolutely. It's for the community spouse. That gets you down to the limit of $2,000. So it's pretty easy, as you can see, just some basic expenditures, making them debt-free, and, basically essentially getting the house in the proper condition for her, that we can get spent from $160,000 to $2,000 to make the institutionalized spouse eligible. One other thing we could do with regard to the IRA, rather than cash it in, we can start making regular distributions, at which point in time, instead of 160, we're going to take that IRA off as number one before we even get to the countable resources. Okay, once we spend down to $2,000, we become Medicaid eligible. And again, with regard to retroactive Medicaid coverage, you can get 3 months prior, but you must be alive, and you have to request it, and you have to meet all eligibility criteria for medical assistance at the time the services were provided. Basically, that means for the last day of each of the 3 prior months, you had to have qualified for Medicaid, meaning down to $2,000, but also you have to be income eligible, meaning your QIT needs to have been set up and funded for the 3 prior months. All right, before we move to asset transfers, questions on spend down or on resource allocations?
No questions yet in the chat, Miriam.
All right, well, we will move on to the exciting part of asset transfers. So basically, they asked about these at the initial application. Have there been anything in the last 5 years immediately prior to applying for Medicaid? And you are signing it under penalty of perjury. And so therefore, you know, Medicaid fraud is a crime. So we don't want to do that. So not all asset transfers are improper. Some are proper, some are improper. If it's an improper transfer, you're going to end up with a Medicaid penalty. This transfer occurs, an improper transfer occurs when either the IS or the CS dispose of assets for less than fair market value on or after the look back date. Any transfers for less than fair market value after the look back date are going to be presumed an improper transfer, unless there's a specific exception that applies, and it's your burden to prove that it was not an improper transfer. But again, it's after the look back pay for the purpose of qualifying for Medicaid is what the standard is, but that for the purpose for qualifying for Medicaid is presumed. So we said look back period, what does that mean? What else do we do except have terms to define? We have a baseline date. That is the first date when the individual is both institutionalized and has applied for Medicaid. So this is controllable when you apply for Medicaid. That date is controllable. The look back date is 60 months prior to the baseline date. And this is the earliest date that an asset transfer can be deemed improper. So if the transfer was 61 months prior to institutionalization and application, it doesn't count. The look back period begins with the baseline date and ends with the look back date. And as we said, the definition of an improper transfer is anything that happens during that look back period. If an improper transfer occurred within the look back period, the penalty is restricted Medicaid coverage. This means you're going to be approved for Medicaid with restricted coverage. What that means is there's not going to be coverage for nursing home or home and community-based services, i.e. passport, will not be paid for, but all your other medical expenses will be paid for. How long is this improper transfer penalty period? That's going to depend on the value of the transfer. So we take the value of all of the improper transfers, we add them together, we divide it by 7,453, which is, as of 2022, the average cost of monthly nursing home care. And there is no cap on the length of the penalty period. Penalty starts when the individual is otherwise eligible for Medicaid and would be receiving long-term care services, but for the application of the penalty. If you transferred $74,530, you have 10 months of restricted Medicaid coverage that begins when you are otherwise eligible, i.e. your resources are down to $2,000 and your QIT income is your income eligible and resource eligible, but for that transfer. So how do you cure it? Can you cure it? And the rule provides that when all assets are transferred and returned to the individual, then there will be no penalty. But when only part of the asset or equivalent value is returned, a restricted Medicaid coverage cannot be modified. So this raises the, obviously, if you gave your daughter $20,000 and she gave back $10,000, it doesn't matter. Okay. That will not reduce the period of penalty. It will still be assessed for $20,000. If different question, and there's really not an answer for this yet, but let's say you gave your son $10,000 and your daughter $10,000, and your daughter gives her $10,000 back, but your son does not. And this could be differing times as well. Should the improper transfer period be reduced because you have gotten all of the transfer to your daughter back? It is an open question. Okay. The way the rule is sort of worded, it would seem that, you know, all of these transfers are added together. And so even if you get it back from one and there's transfers to a third party to a different person, it's suggesting that you can't get any of those, still can't reduce it. I think that's a problem with the rule, but it has not as yet been really litigated. So what does this mean during the restricted coverage? As you will recall, we talked about unpaid medical expenses. The effect of an unpaid medical expense is basically Department of Medicaid will pay your bill in full. Your patient liability will be zero, so you can use your income to pay on the back bill. That does not apply for any nursing home costs incurred during the restricted coverage period. So let's look at sort of a timeline and sort of review how this works. Let's say our friend, Mr. R here, went into the nursing home January 1. This is the first period of institutionalization, and the nursing home went and applied that in January of 2024. This is our baseline date then, January 1 of 2024. This means our look back date is going to be January of 2019, 60 months prior, is our look back period. What if Mr. R gave his house away in December of 2018? Let's say December 31st of 2018. What is the effect? None. No penalty is imposed because the transfer was prior to the look back date. What if he gives the house away in February of 2019? Well, now there's a 10-month penalty because it is within the look back period. But how could we fix this? This is an easy fix. Wait, don't apply for Medicaid until March. you have 2 months of incurred expenses, that you can use an unpaid medical expense rather than impose a 10 months of non-coverage. Because if we wait until March, the house was transferred before the look back period. What if the house was given away in February of 2020? Well, now, if you would have to wait till March of 2025 to apply for Medicaid, we have a large gap versus the penalty period, which is 10 months. So back to our friends, Julie and Jim. Julie entered the nursing home on March 1st. She owns her home. Now the home is 74,530. She has $2,000 in a checking account and her Ford Focus. And the nursing home immediately applied for Medicaid as soon as she entered the facility on March 1st. Julie transferred her home to her daughter, Jill, on April 1 of 2019. Here is our poll question number 2.
Miriam, are you able to click back a slide?
Yes, I will.
Okay, thanks.
All right. And there are our facts. Okay. Julie entered the facility on March 1st. She transferred the home to Jill on April 1st of 2019. When will the penalty period expire?
About half the responses. So let's. Last call, get your responses in here in the next few seconds, and then we'll close the poll. Okay, there's the results.
Okay. So some think that Julie will qualify now. Some suggest that it's January 1st, and some say December 1st. It would be 10 months from the time she applied, which by calculation should be December 1st, not 10 months from April, but 10 months from March. She will not qualify now because she has an improper transfer of her home to her daughter. So from the calculation is March 1st, 10 months of uncovered Medicaid.
And you have a couple questions about that, Miriam.
So it is probably January, sorry. I can't add. Go ahead.
Mary said, could she have the home in a QIT?
No. QIT is only for income eligibility. You cannot deposit resources into a QIT.
What about a homestead property exemption for an adult child caregiver?
We're going to get to exemptions next. Yes, that is in our facts. We're not to that, but we will get to those exemptions next.
Joy asked, in this situation, can Julie's daughter re-gift the home back to Julie?
Can she re-gift it back? Answer yes, because at that point she is giving all of the improper transfer back to Julie, and that will eliminate the improper transfer. That is correct.
And then a few minutes ago, Mike had a question. During a restricted period of coverage, is the facility obligated to bill at the Medicaid reimbursement rate, or can they bill at a private pay rate?
And that is always a good question. Our position would be that they would have to bill at the Medicaid reimbursement rate because you are Medicaid eligible. So they should have to bill at the Medicaid reimbursement rate.
Let's see, one more question. Can Julie withdraw the Medicaid application before a decision is made?
She can, but I believe that our opinion is from the first date of application. So once you have applied, it is already out the door. It's not from the date they determine it. It's from the date you apply is what the rule says. Again, I don't know that that's ever been litigated. Okay, but based on the rule, I would say that will not change the result.
One more question. If Jim files for divorce after Julie is admitted?
So if Jim files for divorce after she's admitted, but going back to our resource assessment, if there is a court order, that's going to probably take priority over your CSRA. Okay. But as for the Medicaid piece, they're going to do the analysis based on the fact that they were still married. But if in that divorce, the court says, oh, Jim is to receive this property, I think that takes priority.
All right.
All right.
Questions.
Cool. So let's move on. So what we were just discussing, some transfers are proper, some are improper. There are proper transfers specifically of the home. You could transfer the home to the community spouse. You could transfer the home to the institutionalized spouse's child under age 21, or to a child over age 21 who is blind or permanently and totally disabled. There's also an exemption for your sibling. So if you and your brother or sister own the home jointly, live together, share expenses, etc., and you've done that for at least 1 year prior to entering the nursing home, then you can transfer the home to that brother or sister without penalty. So here was the question that's highlighted about the adult caretaker child. There is an exception for this, but because of the way the rule is written, it is extremely difficult now. The adult caretaker child, you can transfer the home to them if they continuously resided in the home for at least 2 years immediately before the individual went into the nursing home. And the caretaker child had to provide care to the Medicaid recipient to a high level of care, such that it permitted the institutionalized spouse to reside at the home rather than in an institution or under a waiver program. So how do you prove that? Here's where the documentation becomes a problem. These are the rules now for proving or establishing that you took proper care for those 2 years. You have to have a written statement of the date that you moved in. You have to submit the level of care form dated 2 years prior. You have to have a letter from the doctor regarding the kind and duration of the care that you provided that delayed institutionalization. You have to provide a statement of the type of care and the number of hours a day the child provided care, a statement of any full or part-time jobs or schooling the child attended while providing the care, documentation from any service agency that provided care, the dates that they provided the care and the extent and type of that care provided. So the documentation to qualify has become pretty onerous. Now, there's the statement, but you say, yeah, I worked 40 hours a week and I went to school 20 hours a week, then does that still qualify to deny it? There's no criteria provided as to what qualifies as a basis for denying the exemption. With regard to other assets other than the home, the IS can also transfer any assets between the spouses or to a third party for the sole benefit of the spouse, to a blind or disabled child, or a trust for their sole benefit, to a trust for a disabled individual under age 65. And here's the transfer for sole benefit language, that it cannot benefit anyone else, and they must use the resource for that beneficiary during their lifetime. But this is the proper transfers, again, for any other assets other than the home. What about annuities? An annuity is something where you take a resource and you pay an insurance company who pays, who gives you amount of income for the rest of your life generally. If this was purchased after February 8th of 2006, the rules are that that is going to be called an improper transfer unless the state of Ohio is beneficiary in the first position, or in the second behind the spouse or minor or disabled child, for the amount of medical expenses paid by Ohio. It is to be purchased with qualified retirement funds, has to be irrevocable, and you cannot assign that income stream to somebody else. And it has to be actuarially sound. So you could not transfer your home to your child, for instance, and have the child pay the 80-year-old $10 a month with a balloon payment of the rest in 25 years. That's not going to be actuarially sound. If purchased before the look back period, it's not an improper transfer. Again, if it's irrevocable, if it's something where you can cancel it, there are things called variable annuities that are really sort of like, retirement accounts. If you can revoke it or you can cancel it, it's still going to be countable. But if you purchase an annuity, which is irrevocable prior to the look back period, it's not going to be an improper transfer. Similarly, the community spouse can also purchase an annuity as long as the annuity meets the same criteria. So how do we get around the presumption of the improper transfer? And let me pause right here to see if there's any questions with regard to proper transfers at this point.
Don't see any questions in chat, but we can give everyone a few seconds to get your question in. Okay, I don't see anything.
All right. So as to rebutting the presumption of an improper transfer, let's say that the IS or the spouse intended to transfer the asset for fair market value or for other valuable consideration, or that the transfer of the asset was exclusively for a purpose other than to qualify for Medicaid. How do we prove that? Well, with regard to number one, this could certainly be that JFS is looking at the fair market value is what the auditor, 90% of what the auditor says, and the property has been abandoned or in bad shape, etc. That's going to be document. A written explanation with supporting documentation which explains the reason for transferring it for less than fair market value, and the attempts that were made to transfer it for fair market value, and the reasons for accepting less than fair market value for the asset, and whether there's a relationship between the buyer and the seller. Okay, so certainly we've had cases where they sold it to a flipper. Arm's length transaction, document that they aren't related, and that's who they are. They basically flip houses, and therefore it was not a sale for less than fair market value. Documentation is the poor condition, letter from the realtor saying, yeah, there's no way this property is worth what the auditor says because of XYZ, pictures of the damage inside the property, et cetera. Documentation is the basically the answer whenever we're trying to sell it for less than fair market value. Now, obviously, remember the home is exempt as long as you intend to return home. So that may be the easiest solution, and you just let it sit there until it's gone, either through a foreclosure or whatever, to avoid this. But certainly, as long as you can document that you weren't, as I said, intentionally trying to sell it for less than fair market value. But the problem being is that the presumption is that you did do this to qualify for Medicaid, and you have to overcome the presumption. So can you argue that it's not a transfer? Because you didn't transfer it, your attorney, in fact, under a financial power of attorney did it. Generally speaking, they will consider those transfers as yours. You could certainly make the argument, however, that, oh, under this power of attorney document, they didn't have the authority to do it, at which point you're trying to establish that, in fact, it was a theft, filing criminal charges, for instance. That's always a problem for many of our seniors who do not want to file charges against their child. We already discussed was transferred for fair market value. But another way to do that is to say, oh, no, this wasn't a gift of money to my child. This was actually for services rendered, for care they provided, et cetera. Again, the downside or the catch to that is going to be, did they in fact claim the income on their taxes? If it's for services rendered, was there a contract? Or, oh, I didn't claim it as income because it was a gift. Well, then it's not for services rendered. Child sues them under an oral contract to provide services that they didn't, and therefore they're being paid on a judgment. Or the other way of that is sue for money loaned and therefore not gifted, and then establish that child is not collectible. But, you know, in general, it's better to avoid if at all possible. Right? So some of the ones we have been successful with, it was a gift, but it was not given for the purpose of qualifying for Medicaid. Again, now that burden is on the applicant to establish. But grandma's special occasion gifts. So in our case, you do have sort of regular checks that are given to the children that say Christmas on them. They're dated December 25th or for their birthday, etc. That's usually, again, going to have to be a pattern and probably not going to be very successful if you're transferring $10,000. But we have had those cases where there was like 100 here or there, and every one of those checks said December 25th, Christmas, birthday, etc. Tithing, again, this is a pattern. If you are giving money to your church or 10% for a long period of time, clearly that was not to qualify for Medicaid. Traumatic onset of disability. So I used to do this when we were in person, saying, you know, on the drive home, I'm hit by a car. Can't do that here. But let's just say, as my computer's been wonky, that it decides to electrocute me. And now I'm in I've had a traumatic brain injury, so I end up in the nursing home. Transfers that I may have made prior to that, arguably were not for the purpose of qualifying for Medicaid. However, there is case law, certainly in Hamilton County, that it's really going to be age specific. So at my age, there might not be as good an argument as, let's say, someone who is 40 years old. The case with someone an elderly lady who was 80 who transferred her home to her son, was in good health at the time, but within that 5 years, she ended up in a nursing home, and the court basically determined that being 80 years old, she should expect to need nursing home care. This is going to work only in a traumatic situation and probably age specific. Similar with the diagnosis of previously undetected disabling condition. Okay. The younger that happens, the better that argument is going to be. Okay, questions before we do undue hardship?
I'm not seeing any.
Nobody. I've worn everybody out. So frequently, the nursing home tends to let's go in undue hardship first, and this should be the last resort if you don't have any other option. Okay, they will waive it in an undue hardship if the imposition of the restricted coverage will cause an undue hardship, which means that you're deprived of medical care such that your life or health will be endangered, or you are deprived of food, clothing, shelter, or other necessities of life. That's the standard for the improper transfer. It has to be requested in writing. It has to be requested by the Medicaid applicant spouse, someone authorized by the Medicaid applicant, or someone with legal authority to act on behalf of the institutionalized spouse. And you have to show not only the existence of hardship, but there's no alternate income or resources available. They have to document good faith attempt to recover a transferred asset, or that the recovery would cost more than the asset itself. They have to cooperate in any attempt to recover the asset. And if you've already made a request, they're not going to grant you a second one. Now, with regard to our nursing home residents, previously, the rule was that the individual must document that they were going to try to discharge you and exhaust all administrative remedies to challenge the plan in charge. That rule was eliminated January 1st of 2024. But what does that mean effectively? So if this piece is now gone, so you don't have to document that, and you still show, hey, we're going to try to discharge them. Double-edged sword, that our residents' rights provisions were modified so that a nursing home cannot discharge without a proper discharge plan. Can the nursing home properly discharge the resident to an unsafe location? The answer is no, and therefore will the resident be denied medical services or food, shelter, or clothing because of the improper penalty, or the improper transfer penalty? That is a question. It's probably going to depend on your county caseworkers. All right, let's do a little review of our asset transfers. Okay, again, Julie went into the nursing home March 1st. She's married to Jim. She owns her home. She has $2,000 in a checking account. She owns a 2006 Ford Focus. She transfers her home to Jim on April 1st of 2019. Julie and Jim have a daughter, Jill, age 30, who lives with them. Jim transfers the home to Jill on April 1st of 2020. Jill receives Social Security disability. So, poll question number 3. Now we see if everybody's given up or they're still awake. question is, Julie will incur a restricted period of Medicaid coverage for 10 months because of the transfer of the home to Jill. True or false?
Okay. Give everyone a few more seconds. It's true, false. It's a little bit easier. Right, last call for the poll. Okay.
Okay, 75% said false. That is correct. Okay. The key there is what? Jill is a child and she is receiving Social Security disability. Transferred to an adult disabled child are exempt and are not improper. So going through our facts a little bit, Julie's transfer of the home to Jim, no difference, right? Because the transfers between husband and wife have no effect one way or the other. If Jill is age 30, who lives with them, she's obviously an adult child. Jim transfers it to April 1st, 2020. If she's not disabled, then we have to look at some other exemption. But if there is none, then yes, you are correct. There would be a 10-month penalty. That 10-month penalty begins March 1st of 2024. But because Jill could document that she received Social Security disability, she is an adult disabled child, that is now a proper transfer, and Julie is now eligible March 1st of 2024. All right, so let's do a quick summary of what we've hopefully learned on improper transfers. It is for less than fair market value. So just a gift is not the only rule. If you try to undersell it, the property is worth 50 and you sell it for 40, you have an improper transfer of 10. It occurs within 60 months of both application and institutionalization. Then the Medicaid penalty is assessed when you are otherwise eligible for Medicaid. What are our presumptions to or defenses to the presumption that it wasn't a transfer, somebody actually stole it. It was a fair market value transfer. It was for a transfer for a purpose not for qualifying for Medicaid. Proper transfers, non-home, community spouse, disabled child, or pooled trust. The home, you can transfer it to the community spouse, minor or disabled child, the sibling equity exclusion, or the adult child caretaker exclusion. But again, with the last one, you have lots of documentation you must establish. If the transfer is improper, cure it. You have to transfer all of the asset back in order to cure it. Maybe you could start the penalty period with passport. Otherwise, you apply for passport, you qualify for passport, but you can't receive services. Perhaps that's a way of triggering the restricted coverage. Again, you're approved for restricted coverage. You're just not going to get passport services, but at least you do meet long-term care criteria or proven undue hardship. All right. We are like right on time. We got 4 minutes for any questions.
You did have a question for the end. Mark asked, do nursing homes file Medicaid apps as a business model or because of any requirement?
It's generally for the business model. We do, it is to their best interest to apply for Medicaid because frequently our individuals are elderly and obviously in a nursing home, so therefore not able to take care of this. We at Pro Seniors here frequently provide information to seniors or individuals on behalf of the seniors, which can include nursing home social workers. We also provide this training every year to our nursing homes in Southwest Ohio. So it is part of their business model. It makes sense for them to know this. We, obviously in the legal aid community, could not possibly handle the hundreds of nursing homes all across the state. Here in Southwest Ohio, there are 300 nursing homes and assisted living facilities. So obviously, our staff is not going to be doing nursing home medic applications for every nursing home resident. So it is part of their business model. They are also to assist under the regulations. They are to assist in that process, but assist does not necessarily include applying. It gives you the materials to go apply. But again, it makes sense since they want to get paid for them to be acquainted with this and to actually do it as part of their business model. So, other questions?
Looks like this is a related question from Robert. Does Pro Seniors offer a service to clients to help in all these calculations for Medicaid applications to make sure the client doesn't get in trouble?
So any senior 60-year-old calls and talks to one of our helpline attorneys for free for 30 minutes. So yes, our helpline attorneys frequently are trained on these issues and will provide advice to them and to family members on their behalf for their specific situation. We also send out our fact sheets or pamphlets with this information. And as they go through the process, if they have follow-up questions, they can call and get follow-up helpline appointments. Our in-house staff, pretty much in Southwest Ohio, we will look at more complicated problems like a spousal reluctant spouse rule or something, or a pro seniors rule, or them their JFS requiring us to apply for guardianship, those kind of issues for us to take in-house. But yes, our helpline does provide that information, and I would say of our 12,000 appointments, probably 30% of those are on this topic statewide.
Follow-up question to that: if it takes more than 30 minutes, can the client pay for the service calculation?
No, because we're nonprofit. So in that situation, when they go beyond the 30 minutes or whatever, they could set up a follow-up appointment with the helpline attorney. And obviously, if they have part of our services, I should go to that. We're talking about that. Part of our services, as well as the helpline, is going to be a follow-up call or a referral to private attorneys statewide that do Medicaid planning and Medicaid applications, depending on their income and resource levels.
Don't see any more questions. So last call for questions in the chat.
Yep, and we are like right on time. Look at that. Just some, I already mentioned the helpline, our pension rights project. This is one of our attorneys that helps with pension issues. Our senior Medicare patrol, our volunteers that help educate others on Medicare fraud issues. And of course, as I just mentioned, our referral service is a statewide referral to private attorneys who they do charge for their services, but they also some work at a reduced fee. But this is another option after the phone call if there's some work that needs to be done. That is a statewide referral service. All right.
Okay.
So thank you, everybody. Hopefully this has been informative. And again, make use of the PowerPoint for future reference to work through each step as you need. And our next training is going to be in 2 weeks. It is going to be on topic number 3 with regard to Medicaid, and that is estate recovery, which I know is always a hot topic. So please look forward to everyone joining us again in 2 weeks. That would be April 5th at 9:30. I know that apparently there is sort of a conflict a little bit between another training, but as to what court is doing on kinship caregivers. But you know, this one is recorded, and I think that one is recorded. So hopefully you'll join us and peruse the other one at your leisure.
Right. It's at 10 o'clock on the 5th.
Did I say 9:30? I'm sorry.
That's okay. That's probably when it's on your calendar for me.
That's when it's on my calendar is 9:30. Get set up. Make sure that we're ready to go at 10.
Right. But we'll hopefully see y'all back at 10 on the 5th. And when we close out here, you'll get a survey, and I'll also send a follow-up email to you in the next few days. So thanks so much, Miriam.
All right.
Thanks, everyone.
Thank you.